And for the attendees, the presentation tonight is going to be in the format of about 50 minutes. We're going to leave a few minutes at the end for questions. Because of the volume of the group, I'm going to ask that you put your questions throughout the presentation in the chat box, and we'll pick some general topics from the chat box to answer at the end. Also, we do have 2 drawings tonight for the attendees. So everybody that was pre-registered as of 5 o'clock today will be eligible to participate in the drawing. So I'll do that towards the end of the program as well.
Will the PowerPoint be available somewhere?
Yes, we're recording this. It'll be available to board members, and it will also go onto OMNI's website.
Thank you.
You're welcome. Well, it's 6:02. I'm Caroline McCormick. I'm the internal auditor for OMNI Communities. I've been with the firm since 2018. I joined the firm after being the CEO of Association Communications in the Bay Area for nearly 30 years. And now I assist OMNI with onboarding new clients, marketing, and various other speaking engagements, that type of thing. So this is one of my passions, is education for board members, and it's really a cornerstone in OMNI's culture, continuing education for staff and for our volunteer community leaders. So I invited John Hansen to speak with us tonight, who is a local attorney and very well versed in HOA law. And John, do you want to tell us a little bit about yourself?
Yeah, I will. Thank you. I'm an attorney with the law firm Baydaline and Jacobsen. As Caroline mentioned, we represent homeowner associations, and representing homeowner associations is 100% of what we do. I've been doing this work now for about 13 years. Prior to that, I was a deputy district attorney for Sacramento County DA's office. So I have a criminal background in addition to my time doing HOA work. I'm involved in the HOA industry. I'm involved in the board of directors for the Community Associations Institute for our California North chapter, as well as a teacher and instructor with CACM, teaching certification classes for community managers. The topic we're going to talk about tonight is a legal update. So this is what we do day in and day out. So it'll be a topic that I think will be educational for you, and something that I can give you some examples of from my day-to-day job to help you understand a bit more about each of these new laws. I think, Caroline, if you have I believe you have a video you wanted to play, and then we'll jump into the slides and the content for the presentation.
I do. I have a welcome intro from our CEO, and I'll play it now.
Hello, my name is Rolf Crocker. I'm the CEO.
We need the screen sharing back on.
My name is Rolf.
Okay.
Sorry about that.
No, it's I'm not the technical person. That would be screen share. There we go.
There it is.
Hello, my name is Rolf Crocker. I'm the CEO of OMNI Community Management, and on behalf of our staff, our sponsors, and our speaker, it's my privilege to welcome you to our Ask the Experts series. I believe that it's critical for all board members to stay informed of best practices, current events, and new legislation and case law that will affect how you govern your communities. It is my sincere hope that you will find the session valuable, and that will bring you news you can use in the ongoing management of your community. I know some days it doesn't feel like your leadership makes a real difference, but it actually does to your neighbors every single day. Thank you so much for making the time to attend this session. We hope you will make it a regular part of your continuing education, both as a board member and as a community member. Thanks again for attending.
Fantastic. So with that, I'll turn it over to John, and just a quick refresher. If you have questions during the presentation, please jot them down in the chat box, and we'll pick a select few that we can answer tonight at the end of the program and have a drawing.
All right, very good. Thank you, Caroline. As I mentioned, we're going to be covering a legal update for 2022. So these are laws that got signed in 2021. Actually, one took effect in 21. but then really all took effect in 2022. Just as a disclaimer, the purpose of tonight's program is to provide educational content and explain to you some of the new laws. This is not legal advice, so it's important for you to consult with the association's legal counsel about any particular questions you have. This is for informational purposes only, to give you some insight and ideas about what new laws may affect your community association, to help you and the board in decisions that you make and in seeking advice from the association's counsel. A broad overview, we're going to cover first video conferencing under Senate Bill 391. Throughout these slides and in my talk tonight, I'm going to say SB and AB. SB stands for Senate Bill, which means a particular bill started in the California State Senate, or Assembly Bill, which means a bill started in the Assembly before moving on and being approved by the State Senate. Any bill gets approved by both houses in the state legislature and then signed by the governor. So SB 391 is dealing with video conferencing, mainly how you do that during the pandemic. SB 9 and SB 10, these have been talked about a lot in the news, dealing with lot splitting. SB 1101 is dealing with financial issues, including fund transfers and fidelity bonds. AB 1584 is dealing with ADUs and rental restrictions. SB 392 is talking about annual solicitations, emails, and website posting. SB 432 is dealing with associations' elections, including recalls and election materials. AB 502 is dealing with elections by acclamation, so elections and uncontested elections. And then AB 663 is dealing with membership meetings and emergency board action, again, dealing with the pandemic. And then finally, we're going to wrap up with a case, the Brown versus Montage at Mission Hills case. This year was a bit of a confusing year with legislation because we had multiple bills on the same topic getting pushed forward and advanced into committees and then eventually adopted. It's unusual to have two bills on the exact same issue in a particular year. Usually the authors get together and kind of merge their ideas into a single bill. But this year we had multiple. So if you have heard about bills that sound like different bill numbers on the topic that I'm talking about tonight, it could very well be that that bill was passed also, but ultimately one was deemed to be the controlling bill that took effect, and that's what we're talking about tonight. So starting first with video conferencing. This is something that's been done throughout the pandemic. Some of you are still doing it now. And there was a bit of confusion about how associations could meet during the pandemic by video conference. And the reason is because under the Davis-Sterling Act, if the board is holding an open board meeting, so this applies only to open board meetings, not executive sessions. Those can be done solely by video conference no matter what. But in an open board meeting, the law normally requires that there be a physical location where somebody could attend and there'd be a designated person present, where there'd be a speaker phone or a computer set up where they could actually go and sit down and hear or see the meeting happening. This is meant to provide a spot where someone could go if they didn't have phone access or computer access. And this is modeled on the California Brown Act that applies to public agencies. Well, when the pandemic happened, it obviously didn't make sense to have a physical spot where someone could go because we couldn't meet in person. So it wasn't allowed to have a physical place, or it wasn't safe. The governor signed an emergency order suspending this Brown Act requirement and said for public entities, they could meet purely by video or phone with no physical spot where someone could go. HOAs are sort of left in the dark on this. They weren't addressed, but everyone sort of assumed, well, if it works for Brown Act boards, it works for us. We're going to do our meetings purely by Zoom during the pandemic to comply with not only state and local laws, but also just good safety measures. This emergency bill was passed in the fall of 2021. And what this emergency bill did is it clarified that you could continue doing this. You no longer had to have a physical location during a state of emergency when it was unsafe or impossible to meet. And you could do it without a physical location, but it added some more notice requirements. So again, you could keep doing what you've probably been doing during the pandemic, but if you do that, or if you do that in a future pandemic, if one happens, hopefully it won't, but that could happen. There's some extra notice requirements. First of all, your first notice during this period when you're meeting purely by Zoom or by phone, you have to mail the notice out instead of just posting it in your common area. It must give the members a clear statement that they can request all notices by mail if they want to. It must include clear technical instructions for how to log on. So where do you go? What website do you use? What app do you use? Password, meeting number, all of that has to be clearly spelled out. It must list the phone number and email for someone who could provide tech support both during the meeting and before the meeting. And all votes during such a meeting must be done by a roll call vote. So if you are still meeting by Zoom completely without providing a physical location, you have to do all these at least once in your notice. And then during those meetings, do all of your votes by a roll call vote, saying the person's name. John Hansen, I vote in favor. So not a lot of extra requirements, but at least that makes it clear that during a pandemic, you could do your meetings purely by video conference or by phone conference without providing a physical location. You're only required in this type of meeting to do a speakerphone. You don't have to do a video. That's purely optional. If you are doing it for an election, though, in an election, you have to have a video that's aimed at the inspector of elections where people can actually see the ballots being opened. So a little bit of an extra detail there if you're doing it for an election. And then finally, for a hybrid meeting, you obviously have a location, so you don't have to go through the same process. Our next topic is SB 9 and SB 10. As I mentioned before, you may have read about this in the news. It's got a lot of attention in local newspapers and local press outlets because it allows homeowners on single family lots, and single family is kind of an old term of art, but a piece of land where there's a building, owners of that land can now split that lot into between 2 and 4 lots. The idea is you could create more density in regular planned or regular single family home areas of a city or a county. So it's mainly addressing cities and counties. That's the key part of that. There was a question as to whether or not this would override CC&Rs and prohibit an association from stopping homeowners from splitting their lots, because many CC&Rs say you cannot split a lot or you cannot subdivide a lot further. It was never put into the actual legislation that HOAs are exempt. However, after the legislation was passed, the author of the bill wrote a letter to the Legislative Digest, which is the kind of source of legislative intent, saying this bill is not intended to apply to homeowner associations or override CC&Rs. That type of legislative intent can be used in court to say a bill does not apply to a particular topic. So our opinion generally is that SB 9 and SB 10 does not override CC&Rs. You can continue to prohibit homeowners from splitting lots if that's restricted in your CC&Rs. AB 1101 is dealing with financial issues, and AB 1101 did a few important things. One is it further defined how the association is to hold its accounts. Your accounts must be in, or your funds must be in accounts that are either FDIC insured or have other insurance. So it broadened other types of similar type of federal backed insurance programs for your for how you hold your funds. This could be your funds sitting in your operating or reserve accounts or in your investments. Investments are also further restricted. This sort of codified common industry practices that now investments must protect principal. So the principal cannot be at risk. That means no equities or high risk stocks or other types of high risk, well, any kind of stock or high risk investments. So some limiting on what you can do with those funds. And then for management companies, no commingling of funds. So your fund couldn't be commingled with the funds of another HOA. That's pretty common practice for almost all management companies now, but just adding that clarification in the law. The next part of this bill clarified Civil Code Section 5502. What 5502 in another section that sort of mirrors it said is for certain transfers in or out of an association, or rather out of an association's account, but if it went into another account, so if you went out of reserves into operating or vice versa, any money going out of an association's account, if it's over a certain amount, it requires written board authorization. The amount has been clarified now to deal with small and large associations. So if you are an association that is less than 51, the amount of the transfer that requires written board approval is either $5,000 or more, or 5% of your budget, whichever is less. If you are 51 or over in the size of your association, the transfer threshold is $10,000 or 5%, whichever is less. If you exceed one of those thresholds, written board authorization is required before those funds can be transferred. It's a financial safeguard on association transfers. Your management company will work with you on getting that written resolution before the board, so that the board can do that. So that way OMNI can make those transfers without having to have a lot of multiple authorizations being done. You can usually cover several in one, so long as it's detailed enough. Several years ago, you were required to start purchasing what was called fidelity bond insurance. Well, the phrase fidelity bond insurance didn't quite match the insurance lingo that insurance professionals use. So now that's clarified that it is crime insurance, dishonesty insurance, or their equivalent. So insurance to protect against money going missing is a better way to look at it. Our next topic is AB 1584. This bill is dealing with ADUs and rental restrictions. It didn't do a lot with ADUs. The trend for the past several years is that the legislature wants to make it easier for people to build and use ADUs, or accessory dwelling units. What this clarifies is that HOAs can still have restrictions on ADUs, but they must be reasonable, and that means they cannot unreasonably increase the cost to construct, effectively prohibit or extinguish the ability to construct an ADU. Not a huge change, more of a clarification in the law. So for example, if you had such onerous restrictions on ADUs that someone could not build it because you required too large of a setback, or you required an extra garage be added, things like that, that would no longer be allowed under the law, effective a couple of years ago, but now it's clarified that you really can't do that. You are also limited on the way that you can regulate rentals. Rental restrictions have been around for many, many, many years, and they've always been allowed. But over the years, the legislature has been chipping away at how you can restrict or prohibit rentals. Effective in 2021, if you had a rental restriction that capped rentals at less than 25%, or required rentals to have a lease term of greater than 30 days, like a 1-year lease term, that was no longer allowed and was invalidated in your governing documents. You were required to amend that by the end of 2021. Well, that became a big problem for most associations, because the way the law was written was you had to go out to a homeowner vote to accomplish that amendment. So it was mandated by law, but the homeowners had to approve it. So many boards were going out to these elections and running into roadblocks because homeowners wouldn't vote, or they didn't like it. They didn't want to vote in favor of this loosening of the restrictions. Well, AB 1584 clarifies now that, not even clarifies, it actually allows the board now to make this amendment without doing a vote of the homeowners. Some attorneys thought this may have been allowed last year. Some did not. Our firm was in the camp that you were not allowed to do this in the past. This affirms that you weren't, that if you tried to do it by a board vote in the past, it wasn't permitted then, but it is permitted now, which is great news because this is an expensive and time-consuming process. The legislature also gave you more time. So if your documents have one of these rental caps that either are rental restrictions that either caps rentals at less than 25%, or requires a lease term longer than 30 days, you still have time to get this changed. If you don't, the association can be exposed to civil penalties, paying monetary damages, paying legal fees, and possibly interfering with sales. There could be considerable liability if you don't comply with this new law. So for the process by which the board can make this change, it's similar to how you adopt rules. If you are familiar with the rule adoption process, the board first approves the draft rules. Then they are sent out for a 28-day review and comment period where the members can view them, comment upon them. And then the board comes back at least 28 days later, holds another meeting, considers any comments, and then adopts the rule. Same thing applies with these rental amendments. You can make changes solely to comply with the law to bring your rental cap or your lease term into compliance with the law using the same process. Once you do that, the board then will sign and notarize an amendment to the CC&Rs that gets recorded, and that then complies with AB 1584. Shifting gears now to notifications and the ways that the association and homeowners can communicate with each other. This bill, Senate Bill 392, had a lot of really small, minor changes that are minor in their number of words, but important in the way that they actually change the way you communicate with homeowners. This bill also has 2 tiers. One takes effect in 2022, one takes effect in 2023. The one that takes effect in 2023 broadens the use of emails between the association and homeowners. Right now, if a homeowner wants to consent to getting notices by emails, they can fill out a form that says I consent to getting notices by emails, and that's fine. The association has the option, but it's not obligated to use emails if the homeowner fills out one of these consents. Effective in 2023, the association will be obligated to use both mailing and email if the member asks for it. So it's going to add that. So you have to do both now in 2023. Similarly, in 2022, the member could designate how they want to get notices. They can designate that they want to get mailed, emailed, or both. So it's a bit confusing how the language breaks out, but just be aware that starting this year, email is going to be broadened. It's going to be broadened even more next year. So just be aware of how that's being used. If you do have emails, make sure you talk to your manager to work through how this is going to impact how you have to do notices, or if you don't use emails at all and you might have to start doing it, make sure you understand this. It takes even attorneys a few goes to look at this bill to figure out what exactly are we doing this year and what are we doing next year. So just be aware that the use of email is being broadened more in this year and then next year. The third part of this bill is dealing with the use of websites, which is a new change. Many of you may have used websites in the past for providing notices about your board meetings. And it wasn't quite allowed in the past, although there was definitely an argument that you could, the way the law was written. Well, that argument has now been clarified. You can use your website for posting notices of your meetings if your website has been designated as your annual posting, or as your designated posting location in your annual disclosures that will go out at the end of each year. So if you have a website, you can now designate that as your posting location for all notices for meetings and other posted information. And that then can be used going forward. Instead of having to go down to the mailbox and stick up a notice for each meeting, you can start using your website if you have it designated as your posting location. A bit more out of SB 392. This was some confusion that started in 2021. What goes on the membership list? Historically, the membership list is the name, property address, mailing address, and under the old days, it was voting rights. That's sort of been fine-tuned over the years about how voting rights are on there, still arguably on there under the Corporations Code. But phone numbers and email addresses were never part of the membership list. Then in 2020, the law changed and said that email addresses have to be on the membership list if the association has them. This caused a lot of concern about consumer privacy, which is a big issue in California. And it created confusion as to, well, when does the association have an email address? Is it because the homeowner put their name on a form and put the email address on their form? Or is it because the homeowner emailed the manager one day and said, my neighbor's dog is barking? How does that email address end up in our records? Well, now the law has been clarified that The association only has to include email addresses of homeowners who fill out a statutory form where they provide their notification information. That form, you may not even know it exists, but it's mailed out to homeowners every year in your annual disclosures. It's an annual solicitation for names, property address, secondary address, alternate address, all these details that you want to gather about your homeowners. Many homeowners won't fill it out. And the law says if you don't fill it out, your information stays the same as it's been in the past. So that form is where the email address has to get written down and submitted in order to get on the membership list. So protecting that privacy a bit more on email addresses. The next part of this law is dealing with association election materials. Again, in 2020, there was a lot of dust up about a lot of change in elections, and it caused a lot of dust up. One of the changes in 2020 said you had to keep election materials for 3 years. Well, this is a big burden because it'd be these big bags and boxes of ballots and envelopes just sitting around in management companies' offices that associations are having to pay to store. Well, this has now been fine-tuned. You only have to keep your election materials for 1 year. So just 1 year of ballots and envelopes and lists and things like that. After 1 year, you don't have to keep them any longer. And then finally, kind of an odd addition there. So as I mentioned before, email addresses could be on the membership list if someone submits it, but it wasn't clear how they could get it off the list. Well, now it's clear that members can opt out of sharing their email address on the membership list if the association has it. And it clarifies that neither the association nor the manager can sell the membership list. I've never heard of that actually happening, and must have happened somewhere because someone felt the need to pass a law. But nonetheless, that can happen. Again, some more consumer privacy from the legislature for HOAs. Okay, our next topic is dealing with elections, and there's 2 bills dealing with elections. The first one is SB 432. This is just some ticky-tacky little changes. So one change is the inspector of elections. This is the third party appointed by the board to manage the election process, or at least some part of the process, typically the opening of ballots and tabulation of results. That person must be a third party, can't be a director, a relative of a director, a candidate, a relative of a candidate, or a person under contract with the association, i.e. your management company. Inspector can't be one of those 5 categories. The inspector can also have what are called assistants or appointees who help with opening ballots. If you ever had an election, the inspector might have said, hey, can somebody help me open some of these ballots to make them go a little faster? That's fine. But what the law says now is those assistants have to meet the same qualifications of an inspector. Pretty simple, but just some clarification there. Another clarification is the association has to keep what's called a candidate list for every election. Now the candidate list has to include the address of each candidate in the election. I don't know what the candidate list ever happen, whatever it gets used for. You have to have one, you have to save it for a year, and now it has to have an address on there. So not terribly critical how that's going to be modifying your association's records. Again, in 2020, a new requirement was that you had to post a pre-ballot notice 30 days before elections. This made a lot of sense in director elections because you would list out who are the candidates running for the board. Where it caused some confusion was in non-director elections, such as elections to amend your governing documents or special assessment elections. Did you have to provide this pre-ballot notice? Well, you did under the law for the past 2 years. Now you don't. You only have to do the pre-ballot notice in director elections and recalls. If you were going out to vote on assessments or on amending your governing documents, you don't have to do this notice any longer. So it saves you at least 30 days. Another clarification out of 2020, which again, 2020 was this big storm of changes in election laws, left a lot of problems, left a lot of unanswered questions. One of them was, if you recall or you've experienced, association elections move like molasses now. They are very slow. They take at least 90 days, usually closer to 120 days. The problem with that was under the Corporations Code and Corporations Code section 7511, it said if members submit a petition for a recall election, or for any special meeting, you had to hold that meeting within 90 days of getting out a notice, and the notice had to go out almost right away. Well, that created a problem because under the Davis-Sterling Act, you couldn't get an election accomplished in 90 days. So it forced many associations for the past 2 years to violate the Corporations Code in order to comply with Davis-Sterling by doing recalls slower than 90 days. Now the law's been changed. You have 150 days to do your recall elections if you get them. Hopefully you never get one. They're very disruptive, very difficult to deal with, but at least you have some time now that you're not so rushed to try and comply with the Corporations Code. A few other little changes. Again, membership list is only going to include emails if they've been submitted on a special form. And one other bit of an odd change was under Civil Code Section 5200, members have a right to see a myriad of association records, certain financials, minutes, executed contracts. Members can now also see bank statements. The law previously said credit card statements, which is kind of odd because most HOAs don't have a credit card, but it didn't say bank statements. Well, now it says bank statements. So now you have to provide those if a member requests, but you would of course redact those to take out account numbers and other confidential information. A different but more exciting topic on elections is acclamation. Acclamation is the process in which you have an uncontested election. So say you have 3 open seats and 3 candidates running for those seats. And what many associations did for years was they would deem the election to be uncontested, and they would simply appoint those directors or those candidates to fill those seats without holding an actual election. Under the way the Civil Code used to be written, it was you could interpret it to allow this process to occur because there's no need to run an election when there's no contest. The outcome is already predetermined. Well, the legislature in 2020 again passed a portion of one of the bills said that this acclamation process can only occur in homeowner associations with 6,000 or more units. There's like one in California that has 6,000 units, because units means condos. So it was a really odd part of the law in 2020. There's been work on that since, and now associations of any size can do this process, but there are several hoops to jump through, several conditions you have to meet in order to do an election by acclamation. First, you can only do this twice every 3 years. So once every 3 years, you have to hold an actual election, even if it means mailing out ballots and there's no contest, you still have to do it. Your nomination period is going to be extended to 90 days instead of 30. Right now it's 30 for a regular election. If you want to do the acclamation process, you have to back up your start time and do the nomination period for at least 90 days. That nomination notice must have particular information, including the number of positions to be filled, the deadline for submitting nominations, how you submit nominations, and a statement that says in the event that the election is uncontested, that the board will appoint the candidates by the process of acclamation. Then after that notice goes out, between 7 and 30 days before the deadline for nominating, a reminder notice must go out. That says all the same information that I mentioned before, but it also says, here's the list of candidates who are self-nominated so far. And you're going to include that list on there. So that way people who are considering to run will know, okay, I know who the candidates are, and that may influence their determination to run. Additionally, after each person submits a nomination, the association has to submit or send a confirmation email or letter stating, we got your nomination, you're qualified, or you're not qualified, and here's why. And if they're not qualified, you have to give the homeowner a chance to, or the resident a chance to meet with the board. I say resident because in order to be qualified, you must be a homeowner, you must be a member. But on occasion, a resident, like a tenant, will try and run for the board. They're not qualified, you would respond back to them and tell them why. So that process can be done. It can save you some money by avoiding running an election. It avoids the mailing, but only twice every 3 years you can do it. and you have to make sure you follow all these new procedures. Then once the election cycle is over, once this period is over, the board then holds an open board meeting. The names of the candidates must be on the agenda. The board then appoints them at the board meeting and then gives notice to the homeowners of the appointment. So that's kind of buttoning up this process at the end. So it can really save you a lot of money, but you have to start planning for it and preparing for it. And what it sort of means is you're going to be running elections. If you have elections every year, you're going to be in the election process 6 months out of the year, because as soon as you finish, it's going to be 6 months later, you're starting the process again, because now it takes about 6 months to run an election if you want to use the acclamation process. Our last bill before we get to our case is AB 663. This is not terribly exciting for most HOAs. My expectation is that most of you don't have any kind of delegate process, but for some large homeowner associations, they have a voting system of having delegates. And delegates are a group that exists in an HOA. They're like a layer between the members and the board. And the members cast votes to their delegates, and the delegates then carry those votes forward and vote them in an election. Well, this also brings delegates into the fold of being allowed to do meetings by video or telephone conference. So it just broadens that ability to meet remotely for these delegate positions, which were previously required to meet in person, which created a bunch of confusion and problems during the pandemic. So just, again, broadening rights to do meetings by video or by phone. And now the Brown versus Montage case. If you're not familiar with what case law is or an appellate opinion is, what happens in California is when parties litigate a case or a lawsuit's filed, if the case cannot be settled, which 95% of cases get settled, but those that can't get settled, they go to some type of judgment at the trial court level, whether it's through a formal live trial or through written motions. The trial court renders a judgment, decide who's right and who's wrong. Both parties have a right to appeal a negative outcome. And so they appeal to the California Court of Appeal, which is the second layer of courts in California. The California Court of Appeal then makes a decision, and they issue an appellate ruling or an appellate opinion, and that can either be published or not published. A published opinion means it's actually binding precedent, and that is usually done when there's a new issue that has not been heard by the courts before, or there's a split amongst courts. Somebody could also appeal from the Court of Appeals to the California Supreme Court. Now, the Supreme Court is what's called a court of discretion, where they don't have to hear every case that's appealed to them. They can choose which ones they want to hear. The California Court of Appeals, that middle level, has to hear every appeal. California Supreme Court does it. So we don't get California Supreme Court opinions on HOAs very often, but occasionally we do. So those can be really helpful opinions because they really give a good analysis of the law. So that's just some background on what case law is and why we talk about it. We also talk about case law because case law gives facts to a particular law. So it gives some understanding as to where the court came from, why a dispute got there, and how a law is applied. The Brown versus Montage case is dealing with rentals. The issue in Brown versus Montage was the association amended the CC&Rs to prohibit rentals of less than 30 days. The reason for doing this was they wanted to stop Airbnbs, which many of us have experienced and many of us don't want in our communities. So the association did what they should do. They amended their CC&Rs to prohibit those if they didn't want them any longer, and the members approved it. The issue was whether or not it applied to Mrs. Brown. Mrs. Brown had owned her unit, or maybe she had 2 units, for many, many years, long before this amendment was passed. And she rented it out as an Airbnb, and she made a lot of money on it. So then this amendment happens, and she argued, the amendment does not apply to me. I was an owner before this went into effect. What she was relying on in making that argument is that under Civil Code sections 4740 and 4741, it states a rental prohibition is the key term. A rental prohibition only applies to owners who take title after the prohibition goes into effect. So anybody who owns as of the date the prohibition goes into effect is exempt from that rental prohibition. The prevailing opinion amongst attorneys in the state was that a prohibition was like no rentals allowed, or a cap, like a 25% or 20% or 10% cap. Everyone presumed that to be a prohibition because that actually stops someone from renting. Whereas a restriction on the length of a lease, everyone can still rent. They just have a regulation on how they can rent. So everybody always thought, okay, if you apply a rental cap, it's only going to apply to future owners, not existing owners. But if you apply a regulation like a minimum lease term, it applies to everybody. And that's always the way it was done until this case. In the Brown case, what the court held was a regulation on the minimum lease term is a prohibition because it has the effect of prohibiting some people from renting, i.e. it prohibited Mrs. Brown from renting. And so therefore, because she owned prior to it going into effect, she was considered exempt. So it was not applied to her any longer. She was allowed to have this Airbnb. Now, here's the kicker with this law, with this case. Some of you may think, well, who cares? You know, our 30-day lease term has been in effect for 5 years, and you know, that's okay. Well, where this really becomes a problem is, as I mentioned earlier, AB 1584 now well, it was actually AB 1382 in 2021 that stated you could no longer cap rentals at less than 25%, and you can no longer require a lease term of greater than 30 days. If you have to amend your CC&Rs to conform to those new requirements or those new limitations, you have changed it. So now you have to restart the clock. Because what the law says is anytime a rental prohibition is enacted or amended, it only applies to future owners going forward. So if you have had a 1-year lease term in your CC&Rs for 25 years, and that's no longer allowed, and now you have to drop it down to a 30-day lease term, that means that everybody's exempt from any lease term. So your 30 days is only going to apply to future owners. So that can really disrupt how you're regulating rentals in your development if you have a cap on rentals or a lease term of greater than 30 days. So if you do have those, make sure you are talking with the association's legal counsel about A, getting that done before July 1st, because that's not very far away. And B, how is it going to affect how you regulate rentals? Because now all of a sudden you could be opening up the floodgates for who gets to rent or how long their lease terms have to be. And you want to make sure that you're prepared to deal with that. And you've made adjustments in not only your if you have a rental wait list or a list of all rentals, adjusting how that's done and how that's communicated to homeowners. So not a great case for associations. A bit frustrating that this court would consider a lease term to be a prohibition, but nonetheless, that's the way this has worked out. So, you know, if you're trying to look into the crystal ball, looking forward at what is happening with rentals in California, the legislature is becoming increasingly weary of associations regulating rentals, and the courts are falling right behind in looking what the legislature is writing and saying, yeah, we're really gonna limit the way HOAs can regulate rentals. So keep that in mind and maybe adjust some of your practices or look at how you're going to amend your governing documents if you still want to find ways to regulate rentals while you can, because it may not last much longer with the way, unfortunately, the courts and the legislature are going. But that brings us to the conclusion of our content. And so now I think Caroline has some questions that we can go through briefly, and then we can work on our raffle prizes.
Yes, we do. We have a couple of questions, good ones, a lot of ADU questions. What ability do HOAs have to limit the size of an ADU and whether the owner must reside on the property?
Well, that's a good question. ADUs on the size, you know, whether or not you can regulate the size is going to be what's a reasonable restriction in your particular community. And that's going to be on a case by case basis. So if you had a development with, you know, half-acre, 1 acre lots, well, an ADU could be a pretty considerable size on such a lot. Now, the legislature in the local building code have some further definitions on what it can be. An ADU is usually up to 1,200 square feet, but local building codes can vary on that. What's called a junior ADU is up to 500 square feet. And that's typically going to be like a garage conversion or like a casita added on the side of a home. So what you can do will depend on the nature of your development, how big the homes and the lots are, and your local building code. So a good question for the association's attorney to find out what would be reasonable in that particular area.
Yeah, that's a specific question. Probably should go to your individual association council. John, you mentioned during the program that we now have to mail to everyone when we do our first video conference. There is a question about, can that be sent through email if the owner has opted in?
Yes, if the owner has consented to, I'm adjusting my screen here. If the owner has consented to getting individual notice or notices by email, then yes, that any mailed notice could go to them by email with very few exceptions. But on this particular issue on your video conferencing meetings, you could do email if they've consented to getting notice by emails.
Great. Let's see. Oh, does a transfer, and we're talking about the $5,000 or $10,000 transfers, require a public board meeting and agenda item if we only meet quarterly? And can credit unions be an alternative in the new law about where folks can invest?
Those are good questions. I think credit unions are fine so long as they're FDIC insured or have another form of comparable insurance. And I am fairly certain that they do, but you want to check with that particular financial institution to make sure they have that right insurance in place. As far as the written board approval for the transfer, so that the decision to make the transfer is usually going to be in an open meeting, but it could possibly be an executive session meeting. If, you know, for example, you're doing a transfer for a third-party contract, it could possibly be an executive session item. For the most part, I would say it's going to be open board meeting decisions. And if you're only meeting quarterly, what I would say is really get organized on having a resolution to say, okay, over the next 3 months, over the next quarter, we have, you know, these upcoming transfers for a reserve expenditure, a reserve investment into a CD and whatever else, and do a written authorization on all three at one time. If you had to, you could just call a special board meeting, you know, by video conference or phone conference between meetings to try and execute it faster if you had to do one between meetings. Great.
Thank you. Robert, I think your question is again specific to your HOA. It's what about requiring the owner to reside if they add an ADU? And that I think really is specific to your HOA zoning laws, the city, and probably best asked of your corporate counsel.
Yeah.
We had a good one here from Linda. Two things. There was a financial transfers done in the community without any record in the minutes. What's the board's responsibility to follow up on that? I think is the general question. And then there's a question about renters.
Yeah, that's a good question. If it wasn't so any board decision should be done in a meeting, and then they should be reflected in minutes. So if for some reason the transfer was authorized by the board at a meeting and it wasn't reflected in the minutes, you could always amend the minutes at a subsequent board meeting to put that in there to document it. A written resolution can also be part of the minutes. You can attach those to minutes. So that would be an option as well to document that was approved. If for some reason that there's a mistake happened, maybe the board made a decision outside of a meeting, it wasn't done in accordance with the Open Meeting Act, the board could always ratify it at its next open meeting. Say, last month we authorized a transfer. We had to get it done right away. We didn't hold a meeting. We're ratifying it. We're going to put it in the minutes to document that it occurred. You know, as long as it was approved in writing, that's really what you want to do. Because the big part of that law, that requirement, is just having a written documentation that the board is aware of all transfers of money coming out of their account over a certain size.
Okay, all right. And then this is a good one. Sometimes people turn in their homeowner information forms where they list their secondary address, their preference for receiving communications from the HOA. We generally ask if the unit is rented, who the tenants are, and maybe emergency contact information. Some residents are reluctant to turn those in. I'm not sure why, because we really use it for emergency. Is there a way to force people to give us that information? Or what do you recommend? What's useful?
Yeah, that's a very good question. And the answer is you could adopt a set of rules that require some kind of owner registration process where they provide you with some details like, you know, name, phone number, a few pieces of information, and you could make it a requirement for them before they can get their key fob or their mail key. But it can't be too onerous. You know, if you're asking for a lot, that would be an unreasonable burden on them, or it would be slowing down the process to get their get their mail key or their key fob. Then it could be an unreasonable rule, and that's not enforceable. You know, I could see things like having an emergency contact. A court might say, well, that's a little more than what the HOA is designed to do. I think it's okay to ask for it. I don't think you could compel it. And the other issue too is, you know, say an owner doesn't fill out a form, do you really want to be calling them in and fining them for just not filling out a form? You know, there's just some balancing there as to what you want to do, but I think you can require some degree of information if you have it in a rule.
And the follow-up is, and this would be particularly difficult in a community where you had a gate and your gate's programmed to the specific unit and phone number, and people move in and out, and so I don't know how they get in and out of the gate because they never tell us who they are. But that's probably more of a function of how the gate system is set up. But that's another example of why we would need a phone number if they wanted to be programmed into the gate.
Yep, absolutely.
Great. Well, anybody have any follow-up questions? Anything I missed that we'd like to ask John about? I don't see anything in the chat room. We got a thank you for the great information from Linda Pappenfuss and for making it available. So I will go ahead and do the drawing now. We have two drawing raffle tickets tonight. One is from AWT Construction, and they are offering a $50 Amazon gift card. AWT specializes in roofing, painting, siding, general contracting, gutter cleaning, pool decks. They do it all. They work in the Sacramento and the Bay Area. And every registered event attendee tonight was registered by 5 o'clock is in, but you must be present to win. So I have drawn Olympus Heights, Denise Seward. Denise, are you here? Okay, I will try again. The Vineyard, Monique Voss. Okay, let's see who this. Caesar Zepeda, I believe Fairways at Country Club Vista. I don't see Caesar tonight. Okay, the Vineyard, Linda Pappenfuss. I think Linda's here. Congratulations, Linda.
I'm here, thank you. Yes.
You're welcome.
Great.
We'll get you your $50 Amazon card. And then we also have an offer from Trimax Landscape Maintenance. They are strictly a Bay Area firm. They do landscaping, installations, water experts. They've been around since 1972, and they do have quite a few OMNI contracts. They are offering a $75 Visa gift certificate. Mike Lee, the Oaks at Carmichael. Any sign of Mike? No, okay. Bayfront, Margarita Midas. Ville-Maison, Sharon Nielsen.
I'm here.
Yay!
Oh, great.
Congratulations, Sharon.
Thank you.
Thank you. And this concludes our program. We'll be launching these periodically, I think quarterly. And if you have any topics that you'd like to address, we would be happy to take them under advisement. I did put my email and phone number in the chat room for you. And thank you all so very much for coming.
Thank you, Caroline. Appreciate you having me tonight.
Thank you, John. You were a wonderful speaker. I've heard the presentation on the new laws several times, and yours was very, very easy to understand.
Well, thank you.
Thank you.
very much. Have a lovely evening, everyone.
Thanks, everyone.
Thank
Bye-bye.
you.
Bye, guys.
Bye. Thank you. Bye.
Thank you. Bye-bye.
Mhm.